My name is Milmantas. I own and operate Milmantas Immigration Services, a Canadian immigration company located in Toronto. And for over 20 years, I have been assisting foreign nationals in their Canadian immigration matters. As we receive many requests for resubmission of refused applications either for study permits, visitor visas, or super visas, so today's topic is about refusal of temporary resident applications. Why have these applications been refused, and what steps could have been taken to avoid these further refusals? We often wonder why we need professional to help to do something we could do ourselves. Couldn't you just follow the manual, watch the videos on YouTube, ask Google for clarification of some questions, and complete the applications yourselves? After all, immigration provides manuals for a reason. Yes, it is possible to submit some applications without any representation if you have the time and are able to interpret the Immigration and Refugee Protection Act, the regulations, the manuals, the ministerial instructions, and ever-ending policies. Regardless of whether you have followed all the instructions, or at least you thought you have followed, your application for a study permit or a visitor visa was refused. Let's look at a couple of scenarios. The first scenario involves wherein an application for a visitor visa was refused 4 times. The parents wish to come to Canada and to visit their son. The first application for a visitor visa was submitted by a third-party travel agent or a representative in a foreign country. The second application was submitted by the son, who resides in Canada, and resulted in a second refusal. Then the application for super visas were submitted twice, and 2 more refusals were received. Between September 2019 and 22, this couple had 4 refusals, quite a number. And what is the benefit? An excellent job was done in creating a negative immigration history. The processing fees in the amount of $800 were lost, as well as the service fee paid to the previous consultant. Upon review of the file notes, it appears that each application was poorly prepared. And here is the course of action we took. Incredibly prepared new applications, rebutted every point listed in all 4 refusal letters, which were supported by case law and extensive documentary evidence to support the new applications. The applicant's son, residing in Canada, was genuinely surprised how many documents were required, and he genuinely didn't expect so much work that would be required in preparation of these new applications. The applications were approved. A second scenario involves a refusal of an application for a study permit for a minor child. A parent whose daughter's application for a study permit was approved tried to help his friend and used his daughter's application as a precedent for his friend's son. However, a study permit application for this 13-year-old boy was refused, and wherein the immigration officer in the refusal letter stated, "I am not satisfied that you will leave Canada at the end of the stay based on your personal assets and financial status." 13-year-old boy. the applicant is supported by his affluent parents as a child, there is no way that he would be able to have some assets. Another reason for this refusal was lack of employment prospects in your home country. How about this one? Lack of ties to your country of origin, regardless that the applicant's father shared title deeds of ownership of multiple properties, financial records, and business undertakings, and no family members reside in Canada. Once again, in these cases, the applicants submitted their applications themselves with the help of a friend. So it is also possible, and it would appear that these applications were not considered by an immigration officer. Since 2018, immigration is using artificial intelligence systems for the purposes of decreasing the processing time at some visa posts, which receive huge numbers of applications such as China, India, some African countries. This means that some applications are not reviewed by immigration officer. Regardless of how the application is reviewed and assessed, impeccably prepared application is the key. Why? If an application is prepared, well prepared, and it has been refused, an applicant will have an option to file for judicial review. If the application has merit and the refusal is unreasonable, the department will refer this application back to the immigration department for reconsideration by another officer. Therefore, I trust you understand that it is important that the initial application be prepared exceptionally well, which would give the basis to apply for judicial review. Unfortunately, this is our current reality, as very many applications for study permits, visitor visas, or student visas are refused. Therefore, retaining the services of an experienced consultant can make a big difference, as some issues that an immigration officer may consider when rendering their decision are not addressed on the checklist. As professionals, we apply our education, many years of experience, and not just the checklists. So sure, if all fails, you can try again. But each time a new application is submitted, a negative immigration history is created. Wouldn't it be better to seek professional assistance after at least the first refusal? Where is the saving? Also, in some cases, immigration may send a procedural fairness letter giving you the opportunity to explain some issues. However, a travel agency or an unlicensed professional consultant calling himself a consultant will not be able to explain the questions posed. And it is you who are the one who is going to suffer and face the consequences, as it is the applicant's responsibility to choose a competent professional. On the other hand, it is my opinion that applicants are always at a disadvantage when dealing with immigration officers on their own, especially temporary resident applications, because the power and the knowledge are in the hands of the officer reviewing your application. The immigration officer is part of the system and knows how to navigate it, while the applicant is a newcomer to this maze of forms, lists, and supporting documents. And applications for a study permit or a visitor visa are very highly discretionary and are in the hands of an immigration officer. So one way to help level the playing field is to seek representation. With many years of experience, we know what to anticipate from immigration officials, and we build your case based on its individual merits, going beyond the checklist provided by immigration in order to successfully advocate on your behalf. Therefore, if you are intending to come to Canada as a worker, a student, or planning to permanently immigrate to Canada and need help submitting an application, feel free to contact us. We will be honored and happy to assist you. Thank you for watching, and I hope you found this presentation informative, and I kindly invite you to like, to subscribe, to share this channel in order to gain some tips gained over the 20 years of experience in assisting foreign nationals during their journey to Canada. Thank you for watching, and all the best.